Okay, so welcome back to our company law class. So we would like to discuss tonight membership of companies under the Companies Act 2019 Act 992. Now, before proceeding, you will recall that in our last class we discussed exhaustively the constitution of the company, the legal consequences of it, the content of it, how it may be altered or changed. And then we also discuss what we call the supplementation of the company's constitution by the members. The fact that the members can pass what we call or entered into shareholder agreements, so far as the shareholder agreement uh, does not offend statutory provisions. That is what is provided in the law regarding the constitution of the company. So long as they are not breaching that, they can enter into agreement which can affect how they exercise their rights and powers in relation to governance matters of the company. So that was what we discussed. And in case we missed that class, I think the recording is available on our channel. So we are looking tonight at membership of the company, and it is important to emphasize at the very outset that membership is very important, or should I say, pivotal, very central to company law, because it provides a clear picture for us regarding who constitute the corporate body. Of course, we know that the company upon incorporation is a juristic person. Yes, we are aware. Solomon and Solomon, uh, Moko, no, Nkuma, and so on. We are aware of that. But the company has human beings who are the direct stakeholders, the members. So membership will enable us to determine who constitute that. And again, when it comes to governance, how things are done in the company, how decisions are taken, major decisions are taken by those who are said to have ownership stake, so to speak, the members, and they participate in the governance. And again, membership also enable us to determine who enjoys or who bears the rights and obligations created by the Act and also the company's constitution. So, for example, when it comes to dividends, who is entitled to get dividends? Who is supposed to attend no company general meeting, like annual general meeting, extraordinary general meeting? If you have to even pass a written resolution, so that we don't need to hold a meeting to pass the resolution in the usual way of holding a meeting. Who qualifies to sign part of this written resolution? So these are matters which are can be determined when we know who the members of the company are. For that matter, it's important that we pay attention to the provisions relating to membership of companies under Act 992. And it's not difficult, it's very pretty straightforward. So I expect that we shouldn't struggle to appreciate it. Yeah, so in this class, we are going to address definition of membership, the categories or the various classes of members, as it were. In other words, how membership is also acquired and how membership comes to an end or membership ceases. If you're a member of a company, can you lose your membership? and what are the rights of being a member. Of course, related to that is also your obligations. And as we discuss, we will look at how case law or how some of the cases have actually clarified some of these matters. So maybe we will look at section 33. And in section 33 of Act 992, it is provided that the subscribers of the constitution of a company shall be deemed to have agreed to become members of the company, and on its registration shall be entered in the register of members as members. Shall be entered as members in the register of members, referred to in section 35, so to speak. So the analysis we could do with respect to this provision is that at the time of making application for registration of the company, there are certain individuals you call subscribers, those who would actually sign the application for registration or the incorporation. They are called like the subscribers. They may be the promoters or not the promoters, as the case may be, but ultimately those who would sign the documents for incorporation, they are called like the subscribers. And because of that, when the company is eventually registered, when their application is successful and the Registry of Companies issues the certificate of incorporation, their name shall be entered as members in the Register of Members. And for that matter, they become the members of the company at the registration, at the inception. As a class reader here, I would like somebody to volunteer so that I will release the person's mark, and then the person will be reading the relevant provisions for us. Who is going to do that?
My lord, I will do that. This is Mark.
Okay, all right, okay. All right, so when I need something to be read, then you take your provision and then you read it.
Yes, my lord.
Yeah, so we have made the point that those who are the subscribers, those who sign the application document, they are treated by the law to be members when their name is entered in the register upon incorporation. So that is the first one. And then we also have subsection 2. So take subsection 2 for us. Subsection 2, 33(2).
Okay, yes, my lord. Okay, 33(2). Any other person who agrees with the company to become a member of the company and whose name is entered in the register of members is not a member of the company.
Yeah, so if you look at 33(1) and 33(2), what we notice that 33(1) is talking about membership based upon initial subscription. Okay, so it is automatic. That membership is automatic in the sense that you are a subscriber at the incorporation or the registration, and because of that, where the application is successful and the Register of Companies issues the certificate of incorporation, your name will be entered in the register of members. So that is automatic. And if you remember the case of the Paul treatment investment, the Paul treatment, if you remember that case, so for Kufu JSC actually then would tell us about some DNA markers of the company, one of which is the subscribers, the initial members. So membership based upon the subscription in terms of Section 33(1) is statutory, is by law, it's statutory prescription, and is not dependent upon allotment of shares or you pay consideration or any other internal corporate act, as the case may be. And the entry in the register is a legal consequence of incorporation. And that is why Section 83(1) says that the subscriber's name will be entered in the register, referred to under Section 35 upon incorporation. So where the application for incorporation is accepted, then automatically the subscribers' names are going to be entered in the register. And the case of Adishman Gardens in Asibe will later on remind us, and also the case of Conte and Plego will remind us that the register of members is very important evidence as whether you are a member of a company or not. And that is why subscribers, in terms of Section 33(1), which you have read, tells us that their name will have to be entered in the register of companies upon incorporation. So therefore, if at every point in time there is any disputation as whether you are a member or you are not a member, we can resolve that by having recourse to the register of members. If you go into the register of members and your name is there, you are a member. And very soon you notice that in Adishman against Asibe, the Supreme Court will remind us that membership is not based upon whether you have fully paid for the shares allotted to you or not, but more importantly, as whether your name is in the register of members. If your name is in the register of members, you are a member. If your name is not in the register of members, you are not a member. So let's put that in mind. So subscribers are members, and they are the first members of the company. They're the first members of the company. And we have met the case of Adishman Gardens against Asibe already. But we remember the facts. If you've forgotten, go back and read Adishman Gardens against Asibe, where the Supreme Court will remind us that subscribers automatically become members immediately upon registration. And a subscriber's membership does not lapse or does not come to an end by mere internal disagreement or failure to pay calls. And that if a member whose membership was by subscription at the time of registration of the company is going to lose his membership at all, the remover must comply strictly with statutory mechanisms, including forfeiture rules. You recall that in Adishman Gardens and Asibe, there has been this concern that the Asibe was accused of not having fully paid for his shares. So they made the lawyers of the company write to him that if you don't come and pay by this date, then your membership will be considered as having ceased or having come to an end. And it was that misunderstanding which escalated into the litigation that traveled its way all the way from the High Court to the Supreme Court. And then the Supreme Court gave the definitive pronouncement that if there's this misunderstanding as whether the person has not fully paid for the shares that have been allotted to him, and for that matter, he is not a member. Now let's get back to the basis. And the court said that if you go back to the basis, the law is clear that under the equivalent provision of the repealed Companies Act 1963 at 179, which has largely been reenacted as Section 31 of no, the Companies Act 2019, Act 992. The point is quite clear that where your name is registered in the register of members, either at the time of no, incorporation of the company as a subscriber or subsequently you become a member of the company, and that will be it. And you lose your membership only by complying with procedures of removal of members. So let's keep that in mind. In that case, as well as in the case of Lugutera, Energy Engineer, Leconte, and Plego, the court goes back to the old, common law decisions. Nichols' case, a 19th century decision, and Evans' case, where the, you know, the court had made the point that membership of subscribers is not dependent on subsequent allotment of shares. And now, where you have signed on the constitutional document, that is the document submitted for registration, in those days, under, their law, the English law, that would have been like the Memorandum of Association and Article of Association. So once you have signed on it as a subscriber and same is registered, that was sufficient evidence of membership. And Evans' case also will make a similar point that if you are a subscriber, and for that matter, a member by reason of being a subscriber, you remain a member until you have properly been removed from the register. And mere abandonment in terms of maybe you not exercising your rights or exercising what you are supposed to do as a member per se will not extinguish your membership. Again, failure to act. Maybe you don't attend AGM. I'm a shareholder of some companies. They send me, notice to attend AGM because I'm in Accra and the meetings are being held in Kumasi or Ashanti region. I couldn't go, but they cannot treat that as me having lost my membership. No, because that is not the procedure. So me or failure to act as a member will per se not bring about an end to membership, as it were. So let's keep that in mind. Then, apart from the subscribers as members, that is the first members, we also have other members, post-incorporation members. So after the company has been registered, other people may become members. So that is the post, incorporation members. And again, we have a special category of members. We will talk about maybe devolution on death. If somebody is a member and then the person dies, automatically that is transferred to whoever is supposed to benefit from his estate, as the case may be. So let's keep that in mind. So please, let's look at the section 102. Yes, section 102. Can you read that for us?
Yes, my lord. Section 1021. In the case of the death of a shareholder or debenture holder, 1021A, the survivor or survivors, where the deceased was a joint holder, and B, the legal personal representatives of the deceased, where the deceased was a sole holder or last survivor of joint holders, shall be the only persons recognized by the company as shareholders or debenture holders.
Good. So here, we notice from section 102 that if a person was a shareholder, of course, if you're a shareholder, your name will be in the register of members, so automatically you're a member. And you die, your membership or your share will devolve or will be passed on to your legal personal representative. That is, those who have been appointed to administer your estate, be it holders of letters of administration or be it uh, executors or executress who have the probate, assuming you die tacit, having made the will as it were. So that one is by operation of law or transmission of shares by operation of law, and that will make you a member. So that one is different. And of course, we also have those who have just agreed that they want to become members, like they acquire shares and their name is entered in the register of members after the company is actually formed. And where that is the case, that membership will remain. So please take 33.2 for us again. 33.2. We've read 33.2 already, but take it for us. 33.2.
Okay, yes, my lord. 33.2. Any other person who agrees with the company to become a member of the company and whose name is entered in the register of members is a member of the company.
Good. So these are what they call the subsequent members or post-incorporation members. Uh, so after the company is formed, you want to acquire shares, or if the company limited by guarantee, you want to become a member, your name is registered and is registered or entered in the register of members, you are a member. So what I want to emphasize is that the very important thing is that your name is entered in the register of members. That is very important. Your name is entered in the register of members. If your name is entered in the register of members, you continue to be a member and until they've gone through the proper procedure to remove your name from register of members. So that is what I want to drive home. And we have also seen section 102, the fact that if you were a member and you die, your shares will be passed on by operation of law to those who have been given the legal authority called the personal representative. And they would also, for the time being, become members until maybe according to your will. You can will your shares and say they're giving these shares to this person or that person. Then what they call the vesting assent will have to be made in respect of those people. And once the vesting assent is made, their name will be entered in the register of members, and they will now become, if you like, the new members, as it were. But that will have to be done first. But if the vesting assent has not been done, maybe let me explain what the vesting assent is, just in case you've forgotten your succession law. When we say vesting assent, let's say that a person dies and the court grants letter of administration to people to administer his estate. They become like the personal representative, the administrator of his estate. Now, they will have all the legal authority which the deceased person had in respect of whatever property that constitutes his estate. But they are not necessarily the beneficiaries. But the beneficiaries may be some other people of the, with respect to the estate. So where other people are the beneficiaries, they will need to get a document called the vesting assent. Even if you're a personal representative and you're a beneficiary, you still need to do a vesting assent. Vesting the property in the beneficiary so that from that moment, the beneficiary who will be given the document called the vesting assent will be able to take all the requisite legal steps as far as the property is concerned. So let us keep that in mind. Please, let's look at the subsection 4, 33.4.
Yes, my lord. 33.4.
Yes.
In the case of a company with shares, each member is a shareholder of the company and shall hold at least one share.
Good. I want us to emphasize this that if it's a company limited by share, as the name suggests, as we discussed when we were talking about the types of companies, by definition, every member must have at least one share. You cannot be a member of a company limited by share and say that you are shareless, you don't have any share. No. That is conceptual impossibility. You must have at least one share. So let's keep that in mind. And that is why Section 33, um, Section 33, 4 is quite emphatic that if we are dealing with a company with shares, then each member is a shareholder and must have at least one share. And for avoidance of doubt, Section 33.5 will tell us that, read for us.
My lord, section 33.
5.
Okay. A holder of a share is a member of the company.
Good. So for avoidance of doubt, a holder of a share is a member of company. But there's a sort of like a interpretation problem. Now, if oftentimes when we talk about membership, you tie it or we link it with having your name on the register of members. But if we have a provision like 33.5, which says that a holder of a share is a member of the company, does it mean that it's no longer necessary for your name to be entered in the register of members as an evidence of membership? Yes, what do you think? Yes, what do you think? If you want to speak, just raise up your hand. Let me state it again. All along, we'll be discussing that if you're a member of a company, your name should be in the register of members. And it doesn't matter whether you are fully paid for your shares or not, and so on. But then we also come across Section 33.5, which says that a holder of a share is a member of the company. My question is, does it mean that it's no longer necessary for you to have your name entered in the register of members? I hope you are with me.
Yes, my lord.
Yes, my lord.
Yes, my lord.
Yeah, so what do you think?
My lord, the fact that the person is deemed as a holder of a share in the company means the person is recognized. That means there's an evidence that showing that yes, the person owns a share in the company, which makes him a member. So there should be an evidence.
Okay.
Or there's an evidence there showing that yes, that person has a specified or specific shares in the company, which makes him a member.
So in that case, is the being entered in the register of members, is it necessary or not necessary from what you are saying?
My lord.
Yes.
The fact is that fully paid members
Is it is it
who
is it Badu talking or Michael?
is Badu, please.
All right, okay, after Badu, then Michael. Okay.
Okay. So, my lord, members who are fully paid and they have to be part of the company. So, despite that you have paid, if you have not fully paid the shares that you opted for, meaning they cannot or you cannot be part of the company. because only fully members have to be listed, and their names must be in the register when presenting for registration, my lord.
Great.
My lord,
Yes, Michael.
I think the name to be in the register is a requirement. So it's necessary to have the name in the register.
Can you explain why it's a requirement?
Looking at the provision of the law, just the one Michael read, the name in the register is necessary. So it can never be off the register to have membership status. Outside it will not be possible. That's my explanation.
All right. Thank you.
My lord,
Yes, Francis.
I also think, as my brother said, what you stated in the beginning, at pre-incorporation, the names of the members should be entered. And if subsequently somebody also buys a share and becomes a member, his name, his or her name should also be added to the register.
Okay. Okay, so just to convince ourselves regarding the correctness of the submissions, which have made that the proper understanding of the law is that entry in the register of members is a necessary requirement in terms of evidence of membership. Let us look at section 35, and particularly so, if you look at the section 33, 1 and 2, they all make reference to the register of members. So section 31, 33, 1 told us that the subscribers will have their name entered as members in the register of members referred to in section 35. And then those who later on become members in terms of section 33 2, we are also told that their name will be entered in the register of members as members. So therefore, having your name in the register of members is an important evidence of membership. And the case law, at the Shemine Gardens and Asibe, a case like old cases like Conte and Peglo, Conte and Peglo, although it's a case under the old at one. That one was not even Switzerland at 179. It was under the old law, the ordinance one. They all reinforce the point that having the name in the register is important. So in the Content per Globe, for example, there was this company, J Conte Limited, which was being wind up. And during the winding up, the suit arose regarding who qualified as a contributory. So the official liquidator appointed to see to the winding up needed to settle the list of persons deemed to have been members for purposes of determining who the contributory. Now, most of the company documents, according to the report, have been lost, and the only reliable evidence was the minutes of directors of the company. The directors had a meeting, and I think 12 February 1959, and then the minutes showed the following shareholding, the names and then the share. If you look at the law report, J. Conte, then the number of shares, 5,018 shares. Mrs. Conte, 1 share. N.Y. Asari, 1 share. Dr. A.Y. Peglo, 1 share. and then others 1 share each. So this was information available from the minutes of the directors' meeting of the 12th of February 1959. Now, Dr. Peglo, who had only 1 share, reflected against his name in the minutes, claimed that he had later been allotted 10,000 additional shares. And he claimed that that had been given to him free of charge. He didn't have to pay for that because he had rendered services to the company. And he supposedly had like a letter from the company, Conte. So the court accepted his claim and held that instead of having 1 share, as reflected in the minutes of the directors' meeting, he rather had 10,001 shares. So the matter traveled up to the Supreme Court, and the Supreme Court disagreed with the High Court and reversed the High Court decision. And among other things, the court had to confront the core legal question whether a mere allotment of shares, evidenced by a letter and oral testimony, make a person a member of the company or not. So the Supreme Court, if you read the decision, it's a very short decision, so I will encourage you to read it. If you read the decision, the Supreme Court reaffirmed what the orthodox position is, that membership arises when 2 distinct conditions are satisfied. First, it will be a binding contract to take shares, normally arising from allotment or issued, and 2, entry of the person's name in the register of members. And that's what is important to us. If the person's name is entered in the register of members. And the court will make the point that all those requirements must be satisfied cumulatively or conjunctively, not disjunctively. So if your name is not registered, is not in the register of members, there's no membership. Despite the fact that allotment has been made to you, as it were. So let's keep that in mind. So allotment, which could be an offer of shares, so to speak, to you by the directors of the company, as it were, per se, will not make you a member. And the court was of the view that even if we interpret the allotment letter as an offer of shares or an acceptance of an earlier application, the allottee, that is the person to whom the allotment has been made, must accept the offer and satisfy any conditions such as payment, and then be entered on the register before becoming a member. So if you are not entered in the register, you are not a member. So Dr. Peglo, if we read the judgment, relied on a letter which stated that he had been allotted 20% of the whole shares. And with respect to that, the Supreme Court was of the view that, well, as a matter of technical company law, the word allotted in the letter, that is allotted 20%, will have to be interpreted in the legal sense and not a lay or ordinary sense. And in that case, the letter could at best represent one of 2 things: either an offer of shares or acceptance of what? An earlier request, but not a completed transfer of membership. So if you look at the facts, there was no evidence provided by Dr. Peglo that he had actually accepted the offer. And for that matter, no binding contract arose. And once there was even no binding contract, it follows, naturally that his name will not be in the register of members. And what was a decisive fact of the matter before the court was that the minutes show that he had been given only one share, as we have talked about, and that his name had never been entered in the register as an owner of 10,001 shares. So once his name was not in the register as owner of that number of shares, as far as the 10,000 concerned, he was not an owner of 10,000 shares. So the most important thing and the takeaway for us is that membership goes with entry in the register of members. And if for nothing at all, Adesheman Gardens against Asibe should make it very simple for us, where the Supreme Court will say that either your name is entered in the register of members and you're a member, or your name is not entered, so you are not a member. And I think that is a very straightforward matter, and it doesn't call for any serious debate, as it were. So let us keep that in mind. So I presume that we are all clear regarding the category of membership. One, by subscription at the time of incorporation. Two, those who agree to become members under 33(2), and membership by operation of law. That is the devolution of shares, as we saw, or transmission of shares, as we saw under section 102. So I would like us to look at the register of members before we talk about the rights. Yes, so let's look at section 35.
Section 35, Register of Members, 35(1). Subject to the Central Securities Depository Act 2007, Act 733, and any other enactment, a company shall keep in the country a register of the members and shall enter in the register. A, in respect of members of the company. AI, the names and addresses of the members, and in the case of a company having shares, a statement of the shares held by each member and of the amount paid or agreed to be considered as paid on the shares of each member and of the amount remaining payable on the shares. II, the date at which a person was entered in the register as a member. III, 3, the nature of the interest of each member. And IV, the date at which a person ceased to be member.
Okay, good. So before he continues, first of all, in 2007, there was a law which we call the CSD, Central Security Depository Act, which introduced what we call the dematerialization of the share certificate. Now, for certain categories of companies whose shares are traded on in like let's say, stock exchange or the securities market openly, they are now processed under what we call the dematerialized share certificate regime. So that for those companies, if you acquire their shares, they don't need to give you a paper share certificate. They'll just give you a number. And if you enter the system and your number ID is put there, it will pull up all the information standing in your name with respect to the shares that you hold in that particular company. So for those companies, you do not have what we called the register of members, which we are discussing in the sense that we have. But apart from that, majority of companies still have the traditional system, register of members. And the register of members is supposed to have, a certain information which will enable us to know who have got certain interest in the company. And we will also be looking at the fact that it's permissible for third parties or outsiders to go and conduct a search in the register of members so as to get the clear idea of who the members of the company are. If, for example, you want to buy more shares or you want to offload your shares, you may want to be sure who are members of this particular company, or when did this person become a member, how many shares has the person got, and so on. These are very important information which you may need, and you can only get it. Please put your mic off.
At the magisterium's behest, the bears are capable.
Now I have just decided not to lock the mic. Because I want you to learn the discipline of putting your mic off yourself. So let it be part of you so that when you are taking part in any online session, you not run into difficulties. So I've deliberately not locked the mics, okay? Thank you. Now, another thing, which is a new addition to our law, and that is what we are going to see very soon under the B. If you look at the B, the 35 1B was not part of our law. If you look at the repealed at 179, if you look at the repealed at 179, we didn't have what we are going to see under 35 1B as being part of the law. And it's an attempt to deal with, money laundering and then corruption in state governance. That is why 35 1B has actually been included. So if you look at the equivalent of the current 35, it was the repeal, section 32, the repeal at 179. If you examine it closely, you notice that what we are going to look at with respect to 35 1B was not part of the law and is a new addition. So please, let's look at the 35 1B.
Okay. 35 1B. In
Yeah.
respect of each beneficial owner of the company, I, the full name and any former or other name of the beneficial owner, II, the date and place of birth, III, the telephone number, IV, the nationality, national identity number, passport number or other appropriate identification, and proof of identity, V, residential, postal and email address, if any, VI, place of work and position held, VII, the nature of the interest, including the details of arrangements, including the details of the legal, financial, security, debenture, or informal arrangements, giving rise to the beneficial ownership, and VIII, a confirmation as to whether the beneficial owner is a politically exposed person.
Okay, good. So as I indicated, this is a new addition. And if you look at the 35 1B, it talks about beneficial owner. And I told you at the beginning of this course that when you come across a word or a phrase in the law which does not look a regular word or phrase, quickly go and check the interpretation section of that enactment to find out whether the lawmaker has actually provided a stipulative or a particular meaning to that phrase. So let's jump to the first schedule, the definition sections. If you go to the first schedule, beneficial owner is defined over there. It's page 301. So tell us beneficial owner. Read for us. When we say beneficial owner, what does it mean? Because the 35(1)(b) start with the fact that in respect of each beneficial owner of the company, you must provide the information. So who is a beneficial owner?
My lord, page 301.
Yes. That is the first schedule, the definition sessions.
Okay. Okay, beneficial owner means an individual A who directly or indirectly ultimately owns or exercises substantial control over a person or company. B, who has a substantial economic interest in or receives substantial economic benefits from a company, whether acting alone or together with other persons. C, on whose behalf a transaction is conducted. Or D, who exercises significant control or influence over a legal person or legal arrangement through a formal or informal agreement.
Good. So that is who a beneficial owner is. Now, in practice, let's suppose that you get someone who is working and the person's income is not even up to 5,000 Ghana cedis. And then you see him acquiring substantial shares, let's say shares worth about 500,000 Ghana cedis or 1 million Ghana cedis. It may be Scancom or MTN or any other company, GCB, or just name it. Now that should raise a flag. Could this person be the rare person for whose benefit this share is being acquired? Or he just an alter ego, just fronting for someone? So that the rare owner, the rare beneficiary is hiding somewhere. So that is the rationale for having this new addition in the law, section 35(1)(b), that we need to have a disclosure of the beneficial owner. And this is important because if you don't do that, and later on, maybe there's a problem, we are doing investigation, you will not be able to explain how you came by the money you used to acquire the shares. And mind you, those who indulge in money laundering, and then corruption in public and private sectors, they will steal the money or the proceeds of crime, and then they will give the money to people to buy shares as a way of washing the money from its original crime character. So the lawmaker would like to plug that hole, and that is why since 2019, it is the law that if you are going to acquire shares for someone, you need, even if you are going to acquire it in your name, you need to disclose the details of the person who actually stands to benefit from the shares that you are going to acquire as it were. So look at the BIV, the fact that we have the nationality, the national identity number. So that should tell you that we are not only targeting those who might have stolen money or some other things and have decided to divert it through other people to acquire what? To acquire shares in companies for them. You can get someone who has stolen money or who has indulged in some predicate criminal offenses from other jurisdictions, and they want to channel the money into investments, safe havens, let's say in Ghana. by giving it to people to acquire shares. And that is what the law is targeting. And that is why VII say that you also need to know the nature of interest, like what sort of interest or what sort of arrangement has given rise to the beneficial ownership. So we're interested. So for example, if the person, let's say that I'm buying shares, you're not my relative. You're not my, you don't come from my family, you don't come from my town. I mean, there's no direct relation, but you are maybe super rich or something somewhere, and I am fronting for you. We need to get an explanation as to how our relationship came about so that we understand why I am the one buying the shares for you. Okay, someone has asked a question. One free for that. My lord, per days, can someone go for a loan to purchase shares? Okay, if you have gone for a loan to buy shares, the evidence will be there. The evidence will be there. In any case, I mean, from the point of view of a prudent investment, I find it quite worrying. If anybody will go and take a loan to go and buy shares, why will you do that? Because the loan will take an interest, isn't it? So the loan is attracting an interest. How much are you going to get in terms of dividends returns over a period within which the loan is only supposed to be paid back? But of course, that is the person's own choice. But the other point has to do with the VII, a confirmation as whether the beneficial owner is a politically exposed person. So whether is a politically exposed person, that will have to also be disclosed. And that one is also drawing our attention to corruption in public sectors. So when we say someone is a politically exposed person, the lawmaker has given a definition of what that phrase means. So please go to page 307, that is the first schedule, and tell us who a politically exposed person is. What does it include? Are you there? Politically exposed person.
Yes, my lord, I am there.
Okay.
Politically exposed person includes a person who is or has been entrusted with a prominent public function in this country, a foreign country, or an international organization, including senior political party official, government, judicial or military official, a person who is or has been an executive of a state-owned company, III, a senior political party official in a foreign country, and B, an immediate family member or close associate of a person referred to in paragraph A.
Good. So if we look at the law, it's one of the anti-corruption and then anti-money laundering the mechanism which we have in our country. So as you can see, in terms of fighting corruption, we don't have problem with law. We have good number of laws there, but as whether we have the goodwill to actually implement the law is another thing altogether. Okay, so now we know what the content of the register of members should be, and the fact that if you are fronting for someone, you need to make a disclosure for purposes of entries in the register of members. Now, where the member of the company is not the beneficial owner, other information is supposed to be provided. So tell us what 35(2) requires.
Yes, my lord. 35.2. For the purposes of paragraph B of subsection 1, where a member of a company is not the beneficial owner, that member shall A, provide the company with the particulars of the beneficial owner at the time of becoming a member as set out in paragraph B, and B, update the company within 28 days of change in the particulars submitted under paragraph A.
Good. So if there is any change, it's your duty to actually inform the company. And as you notice, there's a timeline, 28 days. And you notice that when it comes to company meetings, notice will have to be sent. So your address that you are provided, the telephone number that you provided. Now, under the new law, it's even permissible to use other electronic means of communication, emails, and so company information in terms of reports can even be emailed to you, or you may be given a link on your WhatsApp, and you have to. So where the information you have provided, the information has changed, you have 28 days to actually notify the company so that the company will have the most up-to-date information regarding how you may be rich for any other purposes. Now, the other point which is important for us to note is that where you have the register can be inspected by anybody, members of the public, and so on. So please, let's look at section 36. 36, the inspection of the register.
Inspection of register, 36.1. Except when the register of members is closed in accordance with section 37, the register, the index of the names of the members of the company, and the index of the names of beneficial owners of the company shall, during business hours and subject to reasonable restrictions that the company may impose, be open for the inspection of A, member without charge, and B, any other person on payment of a reasonable fee prescribed by the company for each inspection. 2, not less than 2 hours each day, other than a Saturday, Sunday, or a public holiday, shall be allowed for inspection under subsection 1. 3, a member or any other person may require a copy of the register or a part of the register on payment of a fee prescribed by the company. 4, the company shall send a copy so required by a person to that person within a period of 10 days, commencing on the day next after the day on which the requirement is received by the company. 5, where an inspection is required under this section is refused, or where a copy required under this section is not sent within the proper period, the company and every officer of the company that is in default is liable in respect of each default to pay to the registrar an administrative penalty of 25 penalty units for each day during which the default continues. 6, in the case of a refusal or default, the court may order the immediate production of the register for inspection or direct that the copies required be sent to the person requiring them.
Okay, good. So register contains information about who the members are, or if there's a beneficial ownership, including holding it for politically exposed person. All those information will contain in the register. And the content of the register may need to be ascertained either by members themselves. Maybe a member may want to acquire more shares, but he would like to get an idea of what is the shareholding position of members are, so that if he wants to overtake someone in terms of the percentage, for example, in a particular company, I have shares. The last time I checked, I was just probably I think number 6 or number 7 largest shareholder. So let's suppose that I want to buy more shares. So, and I don't want to lose that position, or I even want to do better in count maybe number 4 or number 3, I have to go and inspect the register to find out what the distribution of shares so far are, so as to help me to make the decision. And not only that, there could be so many other reasons for which you need to do the inspection, or you need to find out whether a particular person has actually come to acquire shares and so on and so forth, whatever the reasons are. And that is why Section 36 provides that if you're a member, you can apply to inspect the register for free. You don't have to pay anything. And then if you are not a member of the company will have prescribed a fee which should be paid before you can do inspection. Now, the register of members is supposed to be kept in a location which is publicly known. Like members know, and members of the public also know that it is this place that the register of members is kept. And if you look at the law, it's talking about index of the names, okay? The index of the names is important because just imagine you have a company with about 5,000 members or 10,000 members. And if you need to do inspection of the register, if we did not have the names, systematically and alphabetically arranged so as to to facilitate convenience of search. You can imagine the number of hours that you have to spend just to establish one particular search or the other, as the case may be. And there are times that the register may be closed, as we'll be reading very soon, for purposes of maybe we'll be talking about it pretty soon. So not until the register is closed, then the company has obligation to allow a minimum of 2 hours for availability of the register for inspection during business hours, Monday to Friday, as it were. And where a request has been made for inspection and the company does not comply, as we saw under 36 says, the court will intervene and order the company to comply. And 36(5), where a request has been made and the request is not honored, either inspection or you want a copy of the register to be extracted for you, and you are prepared to pay the prescribed money. You made the request, 10 days have elapsed, and the request has not been granted. You go to the Register of Companies, and administrative penalty units will be imposed on the particular officer or the company, as it were, for not complying with the request so made. So, how the closure of the register of members? When would the register be closed, and what is the purpose, or why may it be closed? So let's look at the section 37.
Section 37. Power to close register. A company may close the register of members or that parts of the register relating to a class of members for any time or times of not more than a total period of 30 days in each year on giving reasonable notice by A, advertisement in a daily newspaper of national circulation in which the registered office of the company is situated, and B, electronic means.
Okay, good. So, when you are reading the newspapers, sometimes you will see that a company has made advertisement that the register is going to be closed from a certain period to period. Like, of course, it cannot go more than 30 days, but they will advertise. So when the register is closed. What it means is that no inspection can be made. And then again, during that period, there may not be entries, as it were. And usually when companies are going to have a AGM, or when they are trying to decide when to declare dividends, it may well be that they may want to close the register so that as at the time of closing the register, if your name has not been entered, then you will not participate in whatever dividends is going to be declared. Or sometimes it may be necessary to carry out administrative sanitization. Maybe you need to update the register, or you need to do any other thing. You can close it so that during the period of closure, the public can actually not go and inspect. But you need to advertise before the closure is made. So let's keep that in mind. Let's look at rectification of the register. If there is a mistake or error of entry, you can get it rectified. So let's look at section 38.
Rectification of register, section 38(1). A person aggrieved, a member of the company or the company, may apply to the court for rectification of the register where A, the name of a person is, without sufficient cause, entered in or omitted from the register of members of a company, or B, default is made in entering on the register any of the particulars which under section 35 are required to be entered on the register. 2.
Okay, before you move on, it is important we appreciate the wisdom or the rationale underpinning section 38(1). Now we have to put it in context with what we've been saying so far, that what is under section 33(1) and 2, and also the case law at Shemine Gardens and Asibe, Lugutera and Northern Engineering, Conte and Plego, those line of cases. The fact that if your name is entered in the register of members, then you are a member. So if you go to section 35, 39, 1, for example, section 39(1), please read 39(1) for us, for me to make my point.
Section 39(1). The register of members is prima facie evidence of the matters which by this act are directed or authorized to be inserted in the register.
Good. So it's a prima facie evidence of whatever is required to be stated in the register, including the fact that if your name is entered, you're a member. And that is why if you're a member of a company, you must also exercise vigilance. Open your eyes and find out that they have not entered names of those who are not supposed to be entered in the register. Because if you ignore and somebody's name has been entered and a person ought not to have been entered because he's not been given shares or he's not done any of the things which should enable him to become a member, the fact that the person's name is entered there will prima facie be what? Evidence that he's a member. And that may go against your interests. Or some error might have been made. They entered that you have 10,000 shares, when in fact you have 1 million shares. We need to take steps and have the rectification done, as it were. So please read the rest of the provision regarding rectification. And let me emphasize that the fact that section 39(1) says that the register is a prima facie evidence of whatever is required to be stated in it. When we say prima facie evidence, it's not conclusive. Mind you, when we're discussing incorporation, that when the certificate of incorporation is issued, it is conclusive evidence of what? Of you having regularly been incorporated. But in the case of the register, it is a prima facie evidence. So meaning that appropriate evidence can be adduced and it will be rebutted, but not until there's an evidence rebutted, then what it says will stand. And the fact that the entry in the register is a prima facie evidence is also consistent with what we have in section 56. Later on, when we are discussing the law of shares, share certificate, right? No, share certificate, if you look at section 56, for example, where share certificate has been issued, we are told that the statement in the share certificate are prima facie evidence of title to the shares of the person named in the certificate as registered holder. So let us keep that in mind. Okay, so now that we know the various, please put the mics off. Evans, check your mic. Yeah, so now that you've looked at the register, what is supposed to contain in the register, how the register may be inspected, and also how the register may be closed from time to time, and if there are errors, how it may be rectified in the register, and the fact that the register constitutes prima facie evidence, we would like to quickly look at the rights and liabilities of members before we talk about cessation of the membership, and then we are done for the night. So, what are some of the rights of a member? If you're a member of a company, and so what? Because it is the rights which you enjoy, which make your membership consequential and worth discussing. And that is why we've been at pains with discussing all these nuances. What are the rights of a member? Let's look at section 34 to start with. Section 34.
Section 34. Right of a member to attend and vote at general meeting. 34.1. Subject to subsection 2 and section 52. A member has the right to attend a general meeting of the company and to speak and vote on a resolution before the meeting. 34.2. Despite subsection 1, the registered constitution of a company may provide that a member is not entitled to attend and vote at a general meeting unless the cause or any other sums of money presently payable by that member in respect of shares in the company have been paid.
Good. So, first of all, when you are a member, you have the right to attend general meetings. That is very important. In the general meetings here, we are talking about AGM, annual general meeting, extraordinary general meeting. Anytime it is convened, you have the right to attend. You have the right to speak. You have the right to vote on any resolution which is being considered as it were. So that is why membership is very important. But as we saw under section 34.1, we are told that there are some instances in which the right to attend general meeting and vote on resolutions may be restricted under section 52. So can you tell us what section 52 says? Section 52. When we are discussing shares, we'll be discussing that, but for now, we just need to put it in context. Yeah, so section 52.
Section 52. Suspension of voting rights of preference shares. 52.1. Despite section 34, the right of holders of preference shares to attend and vote at a general meeting of the company may be suspended conditions. 2, despite a provision to the contrary in the constitution of a company, preference shares carry the right to attend general meetings and on the poll at those meetings to at least 1 vote per share in the following circumstances, but not otherwise. A, on a resolution during the period that the preferential dividend or a part of the preferential dividend remains in arrears and unpaid, the period starting from a date not more than 12 months or a lesser period that the constitution of a company may provide after the due.
Okay, so because you haven't done shares, I don't want you to worry yourself so much with the details of section 52. Suffice to note that the right to attend and vote at general meetings, which every member of the company enjoys, may be restricted, let's say for preference shareholders, under certain conditions specified in section 52 and also the constitution of the company, as the case may be. So that is what is important for us at this stage. We will later come and discuss shares. And when we are discussing shares, we will take our time to explain in detail the provisions of section 52. So let us just note that for the time being. Of course, if you're a member of a company, especially a company limited by shares, you also have the right to share in the profit of the company. So you have a right to share in the profit of the company, and it's part of your right as it were. So when dividends are declared, you are entitled to get your share of the dividends. And later on, when we are discussing capital maintenance doctrine, we will talk about dividends. But for now, dividends are the returns you get when the company has made profit and they decide to distribute a portion of the profits to shareholders for the shares that they have. So the money that you get is what we call like a dividend. So being a member of a company limited by shares, you're entitled to share part of the profit called dividend when it's declared. So let's keep that in mind. We'll later on discuss legality of dividend, that is the circumstances in which dividends may properly be declared. But then let us add that if you're a member of a company limited by a guarantee, you do not have a right to share the part of the profit of the company because company limited by guarantee, as we have noted, they are forbidden from declaring profit, declaring dividends. They are not supposed to make profits to be shared. They make profit only insofar as it's going to be used in furtherance of the objects for which the company limited by guarantee was set up. So if money is made at all, it's not money to be shared. Money to be used to advance the purpose or the object for which the company was registered or incorporated. So let us keep that in mind. So if you look at the section 75 of Act 992, we are told that it is prohibited for a company limited by guarantee to actually pay dividends at any point in time. Again, if you are a member of the company, you have the right to take action for wrong against the company. If the company has suffered the wrong and the directors who are supposed to take the necessary step for the company to seek redress are not doing so, you as a member, as part of your right, you can take it up. You can take it up, and now we have what we call the derivative action. We saw derivative action. We mentioned it briefly, but we come and discuss it substantively when we are discussing corporate governance. But derivative action, in contradistinction to representative action, as you remember, we talk about the fact that where, as under section 201, where a matter ought to have been taken up by the company, but let's say that is not done. Now you are a member of the company. You can seek leave of the court so that you can bring proceedings in the name of the company or on behalf of the company. Or you can intervene in any proceedings involving the company. Now, when you have obtained leave, you obtain permission of the court so as to use the name of the company to sue, or so as to intervene in proceedings in which the company's interest is at stake. We call that derivative action under section 201. And because you are a member, you have the right to take action for wrong against the company. And of course, derivative action is an exception to what is called the rule nefas and habertel, which used to be the case that the proper plaintiff rule, that where the company has suffered the wrong, it is only the company which can take up the matter. But under the new law, we have actually whittled away that common law rule in force and habertel. And it's the position of the law now that derivative action can be mounted, whereby a member will, for example, obtain leave from the court that the company has suffered the wrong or someone has done something wrong against the company. Maybe the board of directors or the members in general meeting have not actually resolved that an action should be taken to redress that wrong. So he or she would like to go to court and seek a redress. So the court should grant permission so that it will be able to sue in the name of the company as if the company is which was taking out the matter. So when that is granted, then the action which will be taken is called derivative action. Derivative in the sense that it is not your own personal action. It's an action which is for the company. So that's why it's like derivative. Yeah, so these are some of the rights which your membership would actually entitle you to enjoy as it were. And maybe the other right we will talk about is the right to share in distribution of the net assets of the company. If you are a member of a company limited by shares, and the company is doing very well, but for whatever reason, they decide to resolve that some of the assets should be returned to the shareholders, or the company decides to embark upon what we call voluntary winding up, voluntary liquidation, saying that yes, we are not owing anybody anything. The company is able to pay its assets and liabilities as they fall due because the company is a going concern, but we just want to fold up and get out of existence, get out of business. So they do that. They take care of all claims against the company. They are settled, and there are still excess assets, what they call it, the net assets. Because you're a member of the company, you'll be entitled to get a portion of the remaining or the excess assets after the various claims against the company have been paid in a voluntary liquidation. So these are some of the rights that your membership actually confer on you. Of course, we know that rights also goes with the responsibilities. So what are some of the responsibilities which being a member of a company will saddle with? So what are your liabilities? What are the duties which go with being a member of the company? So let's look at section 40. Section 40, liability of members.
Section 40. 41. Before the winding up of a company, a member of the company with shares is liable to contribute the balance of the amount payable in respect of the shares held by that member in accordance with the terms of the agreement under which the shares were issued or in accordance with a call validly made by the company.
Good. So first and foremost, if you are a member of a company limited by shares, by definition, your liability does not go beyond the amount of money which is supposed to be paid for the shares that have been issued to you by the company. So therefore, where you had already fully paid for all the shares, then you cannot be called upon to make any payment when the company is winding up, when the company is closing down, as it were. On the other hand, where under the terms of the agreement by which you were given the shares were issued, you had not fully completed paying for the shares, and the company is winding up, you have to come and pay the outstanding balance. Or maybe the company served a demand notice on you, what you call the call, made a call on you to come and pay the outstanding balance, and you haven't complied with. You have to pay during the winding up. So that is a duty or liability that you have in that respect as a member. And this applies to past members, mutatis mutandis. So let's look at subsection 3. Let's jump to subsection 3.
Okay. Subsection 3. Subject to subsections 1 and 2, a member or past member is not liable to contribute to the assets of the company except in the event of the company being wound up.
Good. So if you are a member of the company and shares have been issued, it's not a requirement that you should pay everything. And the company has not made any call on you to come and pay the outstanding portion of the money you ought to have paid for the shares. In that case, you are not supposed to pay anything until the company is winding up, in which case you have to go and pay the outstanding. Or where you have made a transfer of shares. Maybe you've transferred your shares to someone, and you had made an undertaking that, yes, despite the fact that you are transferring the shares, you still bear the responsibility to pay whatever remains unpaid in respect of the shares that you are paying. Then that would be the case if the company is winding up, despite the fact that you're a past member. You can be called upon to come and pay the outstanding unpaid portion because of the arrangement that you made. But beyond that, nobody can ask you to make any payment towards the company as it were. So let us keep that in mind. And that is why in Adeshiman Gardens Limited against Asibe, the court reminded us, speaking through Sofia Akufu, yes, actually then was quote that Section 21 of the code shows that the regulations of a company is not mean document. Once registered, the regulation have the effect of a contract under seal between company and its members and so on. As a subscriber, therefore, the respondent shareholding as well as the consideration payable by him, therefore, is contractual. Unquote. The contractual is what is of interest to us. That later on, when we're discussing shares, when shares are being issued, it's an agreement between the company and the shareholder. So, how the shares should be paid for will be spelled out in the agreement, as whether you're supposed to make a full payment upfront or whether the payment is supposed to be staggered. That will all have to be spelled out in the agreement. So let us keep that in mind. Now let's discuss how membership may come to an end, cessation of membership. And then we're at section 41.
Section 41. Companies ceasing to have members. 41. If at any time a company ceases to have a member and it carries on business without at least one member, every person who is a director of the company during the time it so carries on business is jointly and severally liable for the payment of all debts and liabilities of the company incurred during that period.
Good. Yeah, so it is the law that a company should have at least one member at every point in time. And should it happen that the company did not have a member and the company continued to run, that is not acceptable. And for that matter, during the period that the company was running without membership, any liability which was incurred will be borne jointly and severally by the persons who superintended over the company to carry on business at the time that they knew that the company did not have membership. Now, it is instructive to note that if you look at the old law, I think the equivalent of the Section 41 of Act 992 in the new law, the equivalent of that in the old law at 179 is Section 38. So if you look at Section 30, I want you to look at Section 41. I'm going to read Section 38 of the old law, and then I will ask you if you see any difference. Okay, look at Section 41, listen to what I'm going to read. If at any time a company ceases to have a member and it carries on business for more than 6 months without at least one member, every person who is a director of the company during the time that it so carries on business after those 6 months is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period, unquote. Can anybody tell me the difference between what I read in Section 38 of the Repealed Companies Act 1963 at 179 and what we have just read in Section 41 of the New Companies Act 2019 at 992? Anybody?
This is Benedict.
Benedict, yes.
Yes, so the old law gives a condition which is 6 months, a minimum of 6 months. But the current Act 992 does not specify the duration of which the company should have operated.
Good. Yes, so, interestingly, the lawmaker has taken the moratorium, because I will call it like a moratorium, that under the Section 38 of the Repealed Act 179, if the company ceases to have a member, there was a 6 month moratorium during which the company could run, as it were, uh, without a member. But after 6 months, if there is no member and then the company is still running business, that is where the sanctions will kick in. That if there are debts and liabilities uh, during the period after 6 months in which the company ceases to have a member and then the company was still carrying on business, then the directors or person who are in charge of the company will be made to bear personal liability, jointly or severally, for those debts and liabilities. But if you look at the current rendition, you notice that there's no moratorium, meaning that if the company ceases to have a member, immediately business should not be conducted. If you decide to let the company run business and there are debts and liabilities, the officers in charge will have to bear it and it will not be visited on the company. But then if profits are made, that's why the fact that you made the profit will not be given to you. The profit will go back to the company. So, what are the ways in which membership may cease or may come to an end? So, one, we can talk of a transfer of shares. Transfer of shares. So, if you look at the section 33 6, for example, 33 6.
Section 33(6).
Yes.
Section 33(6). Membership of a company with shares continues until A, a valid transfer of the shares held by the member is registered by the company. B, the shares are transmitted by operation of law to another person or forfeited for non-payment of costs. Or C, the member of the company dies.
Good. So, in a company limited by shares, where there has been a valid transfer of shares, and the emphasis is a valid transfer of what? Of shares. That means that you have complied with the procedure or the conditions for transfer of shares, as the companies might have actually laid down. And if we look at the section 98(1) of Act 992, section 98(1) will tell us that, yes, tell us section 98(1).
Section 98(1), except as expressly provided in the registered constitution of a company, shares are transferable without restriction by a written transfer in common form.
Good.
2.
Yeah, 2.
Subject to section 322, the registered constitution of a company may impose restrictions on the transferability of shares, including power for the directors to refuse to register a transfer and provisions for compulsory acquisitions or rights of first refusal in favor of other members or officers of the company.
Good.
3. A restriction shall not be imposed under subsection 2 on the transferability of any shares after the shares have been issued, unless the holders of the shares consent in writing to the transfer. 4. Despite subsection 1, a company may refuse to register a transfer of shares to a person who is an infant or to a person found by a court of competent jurisdiction in the Republic to be an infant or a person of unsound mind.
Good. So the takeaway from section 33 6A, read with section 98, is that membership in a company limited by shares may come to an end where there has been a valid transfer of shares. And with respect to the transfer of shares, 98 is telling us that unless the company's constitution has actually imposed certain restrictions, as a general rule, shareholders should be able to transfer their shares at will. And then once you have done the transfer, you must get the company to register it so that the new person, the transferee, will now get his name entered in the register of members, and the transfer will have become effective. So let's keep that in mind. Of course, it is permissible for the company to refuse the registration of a transfer if, for example, the person you transfer to is a minor or an infant below the age of 18 years, or the person is does not have the compos mentis, somebody who is actually insane, as it were, then the company can refuse registration. Other than that, the company has an obligation to register the transfer. Now, apart from transfer of shares, membership may also come to an end by transmission of shares by operation of law. We've seen transmission of shares by operation of law already. So, in terms of section 33, 6, as you read, that if you're a member of the company, it continues until the shares are transmitted by operation of law to another. And I want you to pay attention to the expression transmitted by operation of law. So it is the law which is saying that when the specified situation exists, the shares are considered to have moved from the original shareholder to another person, and is not dependent necessarily on the will or the approval of the original person. It is the law which is deeming that situation. So let us keep that in mind. That is why we earlier on read section 102. We look at section 102, if you remember that if a shareholder dies, then the survivor, like if, for example, we have like a joint shareholders, maybe two or more people holding a share, and then one person dies, then the survivors will be deemed to have actually become persons recognized in law as the shareholders. Or if it's just a sole shareholder and he has died, then his personal or his legal personal representative, those who have been given the letter of administration or the probate, as the case may be, they will be considered as the shareholders. So let us keep that in mind. So in this case, the ownership is transmitted by operation of law, or it devolves on the person by reason of the person being the legal representative. Now, apart from that, it can also be transmitted by operation of law, apart from like death situation, also when it comes to bankruptcy like proceedings. Maybe if a person has been declared a bankrupt, we have an official who is appointed to take charge of his or her affairs, either trustee in bankruptcy, as it were, then that will be it. So when a person automatically he ceases to be a member of the company, and things will devolve as we have seen. And there's a case we've mentioned already, the case of a politics against the Plastico Limited, 1967 Ghana Law Report, page 9. We discussed it in our previous classes. So in Politis and another against Plasco Limited, that is EMISA quoted a provision which is similar to what we have, what we'll be reading, but under the old law, that used to be section 99.2. It's equivalent of the section 102 that we'll be reading. And he quoted it as follows, that but it will appear from section 99.2 quoted above that upon the production of such evidence as a company may require, a personal representative is entitled to automatic registration as a holder of the shares of the deceased and therefore as a full member of the company, unquote. So speaking in relation to equivalent provision of section 102 in the current Act 992, in Politis against the Plasco Limited, Mr. J was trying to say that once a person dies, then the necessary evidence will be provided. So in this particular case, if the letters for administration is provided, that will suffice for the company to enter the details of the personal representative as the new members. Another means by which membership may cease is by forfeiture. Forfeiture. Forfeiture, if we look at the section 33, 6b, that membership continues until forfeited for non-payment, of course. What does that mean? If we look at section 61 of Act 992, we will come to notice that a company has the power to forfeit. Forfeiture means that cancellation, okay? If they forfeit your shares, meaning that your share is cancelled, we've cancelled it. We're not going to give the money to you, we've cancelled it. Where, for example, you have paid only a portion of the price agreed to be paid, or where you haven't paid anything at all, and the company has actually requested that you make a payment, in which case a call is made on you. When we say a call, you're not talking about a telephone call. A call means a formal demand notice is served on you by the company that come and pay the unpaid price of your share. And you, for example, ignore it. Now, if a duration has been prescribed and that has actually been exceeded and you've ignored it, the company will go ahead and forfeit the shares. I mean, that cancel the share which have been issued to you and you cease to be a member. So that is it. So read section 33 says in conjunction with section 61, subsection 3 of Act 992. And again, in Adeshimine Gardens against Asibe, which we have quoted or cited already, the court reiterated the point that the forfeiture is a legitimate means by which the company may actually bring membership to an end. And of course, we also have death of the member of the company. So if you look at this is 33 CC, that when the member dies, as it were, then the membership will have come to an end, as it were. And then if it is accumulated by guarantee, then in terms of 33.7, the membership will come to an end. Either the person dies or the person retires or the person is excluded. In company limited by guarantee, you can be dismissed from the company, particularly where you have associations and so on. They have their own rules and they may provide when you may be excluded from membership of the company. So in a nutshell, these are the circumstances in which the membership may be lost. So just before we end the class, we have noted that membership of a company is very important because it enables us to know how various rights may be asserted against the company or how certain liabilities or duties may actually be demanded of certain persons. We've looked at the modes of acquiring membership that you have, if you like, membership at the subscription when your name is entered in at the time of the registration. And we saw at the Shemine Gardens, we saw the Paul Wood treatment. And again, we also have subsequent membership, those who have later on, after the company is incorporated, agreed to become members. In whichever case, your name should be entered in the register of what? Of members. That we've also seen how membership is acquired by operation of law, maybe such as a transmission of shares upon the death of the shareholder and so on. That we also noted that the register of the company is important. It must contain accurate information about the holder of the shares, as it were. And if there's a beneficial ownership, that is, the shares which are held in your name, you are not the rare beneficiary. It's somebody behind who is a beneficiary. You are supposed to disclose that. And if the beneficiary is also politically exposed person, that fact should also be disclosed. And we have noted that the register should be available for inspection by members for free and non-members at a fee prescribed. And the register may be closed, not a period, not exceeding 30 days in the year. And we have also noted that search can be conducted, copies can be demanded from the register, and all that should be respected. And we have also discussed the various rights of members. You have looked at the duties, and you have looked at how membership may actually come to an end or cease. And more importantly, we've also noted that there's been an important change in the law, that unlike the old law, where a company without a member will continue to run for a period not exceeding 6 months. Now, it is no longer the law that at any point in time, if the company says you have a member, it shouldn't conduct business. Otherwise, officers who superintend over the company, when you conducted business with that member, will have to personally, jointly and severally bear any debts, liability for any debts and other liabilities which may actually arise. So in a nutshell, these are the matters that we have discussed tonight. Because your exams is coming up, there's a one topic more which we needed to discuss, but I don't know whether it will be appropriate for us to get a time to do that. So we probably have to add it to second semester topics, as the case may be.
Yes.
Yeah, so because they didn't do a formal